Welcome to the new wave of feminism. Welcome to each other. Welcome home.
Care centers for mothers, child abortions for anyone who wants them.
From the Equal Pay Act to Title IX and the Women's Business Ownership Act, the 1960s, 70s, and 80s in the United States didn't just reshape policy. It rewired a national psychology, and 40 to 60 years later has led to unintended discrimination that no one will admit, and is still very much alive and well. The 1960s to 1980s, in fact, marked a shift from equal opportunity to institutionalized protection. That is, creating empathy and accountability lines that still divide genders today. This episode traces the origins of modern double standards, how the laws written to create gender equality in the 60s through the 80s quietly built the framework for the male discrimination that we live with today. In this episode, we'll move through 4 major pieces of early gender legislation step by step. What it established, what exceptions or promotional advantages it created rather than true equality, how those choices reshaped cultural expectations, and the psychological consequences that still define gender double standards today. And as we'll see, each law marks not just a policy shift, but a subtle transfer of moral weight, from equality of opportunity to selective protection and privilege. Between the 1960s and 1980s, the landmark laws that we'll review and some of their subsequent court decisions shifted the terrain of gender and law from overt exclusion to remedial inclusion. On the one hand, they achieved necessary progress in some ways. More women experienced increases in equal pay, education access, bodily autonomy, and business ownership. On the other hand, the legislations entrenched a particular structure of protection and exception. That is, women as a group needing remediation and men being established implicitly as the baseline or default. That framing helped establish the cultural scaffolding for many of the double standards that men are experiencing. For example, men are expected to behave, restrain, and provide. Women are expected to be protected, supported, and given special access or space. In psychological terms, the 4 laws we'll review helped cement roles. Women as recipients of special rights and protections, men as the normative default whose roles and responsibilities are assumed rather than assessed for society's best functional outcomes. And that structural backdrop makes later technological, institutional, and media shifts from the 90s onward more understandable, because they amplify a repurpose of a system that's already skewed by decades of legal framing. So let's start with the Equal Pay Act of 1963.
At the urging of Esther Peterson, President John F. Kennedy signed the Equal Pay Act.
I must say I am a strong believer in equal pay for equal work, and I think that we ought to do better than we're doing.
In 1963, President John F. Kennedy signed the Equal Pay Act, a milestone piece of legislation that made it the law of the land that men and women receive equal pay for equal work. However, 50 years later,
new friend green and a sneaky link. New friend green and a sneaky link. Fake turn hands and a hoop.
Enacted in June 1963, this law amended the Fair Labor Standards Act with an intention to prohibit wage discrimination on the basis of sex. Men and women who perform substantially equal work in the same establishment must receive equal pay. One landmark case for this one is Corning Glass versus Brennan in 1974, which clarified that pay disparities rooted in sex-based job classifications violated the Equal Pay Act. The court ruled that employers could not justify lower pay for women simply because the work occurred on different shifts, setting the precedent that strengthened female wage claims and expanded federal interpretation of equal work. When the Equal Pay Act of 1963 was passed, the dominant narrative suggested that women were routinely being paid less than men for doing identical jobs. In reality, the data behind that claim was far more complicated. The average female worker did earn substantially less overall, reportedly about 60 cents on the dollar, but most of that gap reflected occupational segregation, not unequal pay for the same position and the same work.
To supply the conveniences for modern living, the products we create and build grow ever more complex. And in every supplier plant, each man and woman must work with a feeling of responsibility.
And this is the same misunderstanding that's promoted today. Supporters of equal pay cite industry incomes while failing to acknowledge differences in specific jobs. But back in the 1960s, in sectors where work was standardized and earnings were easily comparable, such as factories, clerical work, retail cashiers, and assembly lines, the evidence of outright unequal pay for identical roles was relatively rare in the early 1960s. Large employers with unionized or government-linked pay structures already used fixed wage scales that applied equally to men and women in the same role. The remaining gaps tended to arise from differences in shift assignments, that is, night versus day shifts, and maybe even physical labor differentials, all technically outside the narrow definition of equal work. Where real disparities did exist was in non-union or locally managed workplaces, especially small-town offices, hospitals, and schools, where pay setting was discretionary and informal. But even there, equal pay for equal work was less about identical job titles and roles and responsibilities than it was about comparative value. For example, male janitors earning more than female cleaners, or male clerks earning more than female typists, even though the work required similar skill and effort. Congress used those examples to make the case for this act, even though the national pattern was driven more by job clustering than by pay discrimination within the same role. While the Equal Pay Act established some protections for women against wage discrimination, there has never been an equivalent measure addressing the structural risks or disadvantages of men's work.
Being a coal shoveler was a tough and dangerous job. Workers had to shovel coal in tight spaces like mines and industrial boilers. This job required a lot of physical strength and stamina because shoveling coal was a never-ending and hard task. The coal dust was harmful, leading to serious health problems such as breathing issues and lung diseases, which made the job even more risky.
The policy logic of the era defined equality narrowly as correcting female underpayment, not accounting for male overexposure to risk or their economic disposability, thereby leaving men's physical labor effectively invisible in the equality debate. The effect of the Equal Pay Act on double standards is that, as one of the first major legal moves to so-called correct gender disparities, the act framed women as a group needing legal protection from male-dominated employment systems. In doing so, it subtly shifted the cultural baseline, such that men were assumed to have the standard pay and women required special enforcement. This then led the groundwork for a pattern in which men's economic roles are normative and women's deviations are framed as exceptions that need to be justified. The psychological consequence of the Equal Pay Act is that over time it contributed to what one might call the male standard versus female remediation mindset. Women's advancement became framed as needing special legislation rather than equal treatment, which reinforces the perception that women are in a secondary or corrective role.
No person in the United States shall, on the basis of sex, be excluded from participation.
From participation in, be denied the benefits of, or be subjected
to discrimination under any education program.
But there's also something new afoot, which is that Title IX starts to be used much more expansively around issues of sexual harassment and what comes to be known as sexual violence on campus.
The second legislation I want to cover is Title IX, which includes Education Amendments of 1972. Passed in 1972, Title IX prohibits sex discrimination in any educational program or activity receiving federal financial assistance. Landmark cases involving Title IX include Cannon versus University of Chicago in 1979, which established that individuals could sue colleges and universities under Title IX for sex discrimination and extending its power beyond administrative enforcement. A second landmark case is Grove City College versus Bell in 1984. This one narrowed the interpretation of Title IX to only programs that directly receive federal funds. But the Civil Rights Restoration Act of 1987 later reversed this, expanding coverage back to entire institutions. Before Title IX in 1972, women were not legally prohibited from participating in educational programs or forming sports teams. There was no federal law prohibiting women from attending universities, earning degrees, or joining athletics. What did exist were institutional barriers, funding disparities, and cultural expectations that made women's participation less prioritized. Keep in mind that by the early 1970s, women already comprised about 43% of college students in the United States, so they were not barred from higher education. At the time, prestigious institutions like Harvard, Yale, and Princeton were still male-only, but many coeducational and women's colleges also existed. The main issue was not formal prohibition. It was reportedly unequal access to resources and professional pipelines. Graduate programs, particularly in medicine, law, and the sciences, were admitting women, although maybe at very low rates, sometimes in less than 10% of cases. And let's be very clear that those restrictions came from cultural norms, not from law. Women were not prohibited from participating. In other words, colleges could discriminate at their discretion, and many maybe did. Yes, a university could decide to not admit women to a department or to restrict their dorms and their facilities. But the truth of the matter is that such practices are happening today, 50 years later, to men. So Title IX's reported remedy was to change that by tying federal funding to non-discrimination, not by overturning an existing legal ban on women and education, but by making discrimination financially risky for institutions. But here's where it gets really discriminatory. Still today, Title IX includes built-in exemptions for about 30 United States institutions that explicitly allow women-only colleges such as Smith College in Massachusetts, Spelman College in Georgia, and Scripps College in California, which are all allowed to continue operating while denying men the same option. So legally, that means the law not only restricts male-exclusive education, but also privileges female-exclusive institutions, which preserves one form of gender exclusivity under the banner of equality. Let me acknowledge that a few historically men's colleges, such as Wabash College in Indiana, Hampton-Sydney in Virginia, and Morehouse College in Georgia, still enroll only men at the undergraduate level, but they are rare exceptions. They are surviving from before Title IX and operating under the same historically single-sex exemption that protects women's schools. The key difference is cultural framing and scale. Those men's colleges are perceived as historic relics, not protected social remedies. So to be clear, no new men-only college could be founded today and still receive federal aid or research funding. In contrast, women-only colleges remain politically and legally affirmed as corrective institutions, making them protected under Title IX's explicit exemptions, a privilege that's not mirrored for men. And here's perhaps the biggest example of the double standard that resulted from Title IX.
New interpretations of Title IX are not only being used against women, they're also being used against men. And once again, we have to go back to the Obama-Biden administration. In 2011, it sought to address what it perceived to be a sexual assault problem on college campuses. Fair enough. But rather than focusing on prevention, it decided to focus on punishment. The administration used Title IX and its language about preventing discrimination against women as the basis for discriminating against men. They did this by requiring schools to assume that the accused in a sexual assault case, mostly men, but not always, was guilty until proven innocent. That's the very opposite of America's innocent until proven guilty judicial standard and an obvious violation of due process, the bedrock of American justice. It's in our Constitution twice.
Although Title IX prohibits sex discrimination in education, its enforcement evolved to focus overwhelmingly on protecting female complainants, particularly after the 2011 Dear Colleague letter. I recommend go looking that up. No complementary statute ensures due process protections for male students who are accused of sexual or any other type of misconduct, which creates a legislative vacuum wherein civil rights protections for one gender can actively endanger the other. A true counterpart to women's Title IX protections would be to guarantee equal procedural rights and investigative transparency for both parties, something that is consistently missing in campus tribunals that often operate under lower evidentiary standards and gendered presumptions of guilt. Many universities interpret federal guidance to mean protect the complainant at all costs. The result is a system that claims moral authority through believing survivors while abandoning neutral adjudication. Male students can be, and often are, expelled on findings reached without witness confrontation, legal representation, or disclosure of exculpatory evidence.
For the woman who falsely accused 2 football players from Sacred Heart University in Connecticut of rape.
Those 2 students were never arrested, never charged with any crime, but the accusation was serious enough, so much so they say they had to leave school, their reputation in tatters. A lie that cost 2 young men their college careers.
My life has been altered and shaped in ways that nobody here could have imagined. So I just hope that, she knows what she's done, and the fact that my life will never be the same. Like, I have anxiety, I have PTSD from this.
Well, the other student who chose to remain anonymous lost a football scholarship over this.
Because these hearings are civil rather than criminal, there's no public record and there's no formal appeal process. Yet the sanctions, which can include everything from expulsion to loss of scholarships or even permanent disciplinary records, carry lifelong stigma comparable to a felony conviction, with none of the procedural safeguards. Another of Title IX's effects on double standards is that it has extended the financing of women's participation in education, which was already legal and reaching gender parity at the time. And it also increased funding for women's athletics, which was underrepresented because nobody wants to watch women's rugby anyway. So while people claim that Title IX's success in opening doors to women was significant, it also further entrenched the narrative of women as the disadvantaged group who required remedy. The psychological fallout of Title IX is that it created, in effect, a cultural expectation that women must catch up, while men's roles remained baseline. More to the point, men's success is implicitly normative and unremarkable. Women's success has become celebrated or qualified. And this builds a double standard in how achievement is framed. Men's competence is just assumed, while women's competence is celebrated as exceptional.
Obviously, it's a concern for all women. All women face the problem of forced childbearing.
I don't want to tie you up now. I don't want to do the thing. I don't want to have you, baby. I just want to have a thing.
Being forced to carry to term an unwanted pregnancy, that is forced childbearing.
The third legislation on our list is Roe versus Wade, which is likely the most polarizing for a lot of people. In 1973, the United States Supreme Court's decision in Roe versus Wade recognized a woman's constitutional right to choose to have an abortion, thus enshrining major changes in reproductive autonomy. Subsequent landmark cases here include Planned Parenthood of Central Missouri versus Danforth in 1976 and Planned Parenthood versus Casey in 1992. Both reinforced or adjusted Roe's parameters by addressing spousal consent and state regulation. In the 1970s and 1980s, these decisions affirmed that reproductive control rested primarily with women, not jointly with men or states. And this is a topic for another day because I'm not entirely familiar with it. But I believe that if there are not already laws requiring a wife to approve her husband's vasectomy, there has at least been some advocacy for it. And maybe I'll dive into that another day. Anyway, here's the nuance. Before Roe versus Wade in 1973, abortion was not uniformly illegal nationwide. It was regulated differently from state to state. A few states, like New York, California, and Hawaii, had already legalized abortion outright by the early 1970s. So at the time, women weren't universally prohibited from the procedure. They were just restricted by geography and circumstance. Roe changed that by nationalizing access. It didn't invent abortion rights. It federalized them. The Supreme Court ruled that the constitutional right to privacy extended to a woman's decision to terminate a pregnancy, thereby preventing states from imposing blanket bans. The effect was to eliminate the patchwork of laws that made reproductive decisions contingent on where a woman lived. So in practice, Roe didn't lift a universal prohibition. It standardized autonomy. It moved the authority from the state level to the federal level. The closest equivalent so-called restriction that women faced before Roe wasn't about legal prohibition per se. It was independence on local structures to grant or deny access. For example, in many states, even therapeutic abortions required approval from a hospital board. Roe replaced that gatekeeping system with women's own consent, making her the final arbiter of decision-making. In my opinion, the functional male equivalent to reproductive autonomy would be mandatory DNA testing at birth and ensuring accurate paternity identification to eliminate the financial and emotional fallout of misattributed fatherhood. While Roe granted women unilateral decision-making power over reproduction, men to this day remain legally accountable for outcomes that they cannot consent to, confirm, or contest. Mandatory DNA testing would not infringe on female rights, but would balance reproductive accountability, protecting men from fraudulent claims and reinforcing the shared ethical premise that both parents deserve to know and be known by their biological child. An effective double standard is that Roe versus Wade transformed the cultural landscape of gender roles by placing women's bodily autonomy at the center of civil rights discourse. While this was a breakthrough for women's rights, it also reinforced a dual role: women as the agents of care and choice, and men as the background or bystanders with less visible agency even for their own reproductive decisions. Whereas legal rights were extended to women, men's equivalent roles or responsibilities have not received the same legal framing, which reinforces an irregularity in how reproductive autonomy and responsibility are culturally accepted. The psychological consequence of this double standard is the dichotomy of perceiving women as empowered actors in one domain, and in another, men as voiceless characters to their own reproductive rights. As with other issues, I would argue that this contributes to the male accountability versus female empathy split that I mentioned earlier. Men are implicitly the default providers, whereas women are framed as recipients of rights, care, protection, or change. This psychological architecture underpins many of the double standards that we see today. Men must be restrained or controlled because they're presumed to be stronger and agents of their own fate. And women must be protected or liberated because they're presumed to be vulnerable or in need of autonomy.
The progress that we're witnessing is just the beginning. hand that pulls the voting lever rules the nation.
We've been living in sin so long, all the feels are gone.
Why aren't women-owned businesses growing faster?
Both systemic and sociological. The number then was 3% of women-owned businesses grossing over $1 million.
And now it's 2%.
And now it's gone down to 2%. We control the wealth in this country. Can you imagine if we could band together?
The fourth major legislation that contributed to the double standards that we see today was the Women's Business Ownership Act of 1988, the WBOA. Signed into law on October 25, 1988, this act established a federal role in supporting women entrepreneurs, including training, technical assistance, and access to capital. Often ignored about the Women's Business Ownership Act of 1988 is that nothing in federal law prevented women from owning businesses, receiving loans, or seeking mentorship prior to 1988. To be clear, before the act, women sometimes faced social expectations and perhaps procedural obstacles, not legal exclusions. For example, some banks required a husband's or male relative's co-signature on business loans in the early 1970s, but this was a private sector policy practice, not a federal mandate. By the late 1980s, when the WBOA was passed, those practices were already declining and nearly non-existent. The act, therefore, was not a liberation from a formal ban. It was a federal endorsement of the preferential infrastructure. It created things like dedicated loan programs, training centers, and procurement preferences for women-owned businesses through the Small Business Administration.
You know that women entrepreneurs are now more likely to get a business loan than men?
Today we're going to be taking a look at 7 of the best small business loans for women.
So in effect, the act shifted from equal opportunity to targeted advantage. It contended that women were underrepresented in business ownership under the auspices of discrimination rather than women's self-selection into business, and used government resources to accelerate their participation. That's why critics argue that it marks the point at which gender equality policy began to function as redistributive support rather than purely corrective reform. The Women's Business Ownership Act opened federal access to financial capital and mentorship for women entrepreneurs. Yet there is no legislative or institutional equivalent supporting male-preferred sectors such as trucking, construction, and the skilled trades. These industries face chronic labor shortages, safety risks, and declining intergenerational participation, but they receive virtually no targeted investment or policy visibility. A true counterpart to the WBOA would have strengthened these male-dominated economic backbones rather than assuming their resilience. Such support would address both cultural neglect and the economic vulnerability of working-class men whose industries are foundational, yet politically unprotected.
I'm a crane operator. 9-10 hour days, building high rises.
Do you have any formal education? Is it required for this kind of job?
I wouldn't say required. Over $100,000 a year.
All I got is my degree. You know, people say, get your degree, but then they don't talk about how you need experience. The degree was the experience!
You know that women entrepreneurs are now more likely to get a business loan than men?
The BOA's effect on double standards is that laws recognized women as active economic agents and sought to remove barriers to female business ownership. However, by doing so within a special support framework, rather than simply giving men and women the same baseline support, it implicitly reinforced the idea that women's participation in business is an exception that needs specialized support. Meanwhile, men's entrepreneurship to this day has remained the normative default, still framed as a standard rather than receiving support. As a psychological consequence, this reinforces the notion that women stepping into business leadership are doing extra work or entering a special category, rather than simply participating in the norm. So men remain the standard entrepreneurs and women are female entrepreneurs, a distinction that subtly fosters a double standard in how competence, risk, and success are perceived. This protective and supportive framing keeps the narrative of women as special cases alive, which ties into broader gender norms about normative roles and exceptional roles. So the 1960s through the 1980s were sold as the age of equality. but they were really the age of deflection and redefinition. Each piece of legislation, the Equal Pay Act, Title IX, Roe v. Wade, and the Women's Business Ownership Act, all promised balance while embedding structural unevenness. None tore down boundaries so much as they rewrote the rules of who needed and who gets protection and who must bear responsibility. Ultimately, equality became remedial, not reciprocal. And 60 years later, men remain the moral baseline, expected to restrain, provide, and absorb, while women are still framed as a class to be safeguarded, supported, and advanced. By the end of the 1980s, the foundation of the modern double standards was complete. A culture that measures justice through empathy, not equity, and calls it progress.
The progress that we're witnessing is just the beginning.
We've been living in sin so long, all the fields are gone. Fella stopped me on the street last night, said everything's alright.